Good afternoon, everyone. Woo! Okay, I'd like to call this meeting of the Health and Human Services Committee to order. And let's get started. I'm going to call SB 96. Senator Watson, you're on.
Thank you, Chair Lady Cooper. I'm sure it's nice to be here and appreciate you letting me go first. This legislation actually passed last year, and at the 11th hour, just was one of the ones that did not get called up there at the very end. I'm not aware of any controversy on this. The bill originally started to relating to cleanup legislation in hospice care. So it's been ongoing for a couple of decades now that RNs or nurses in the hospice program can pronounce death. This has nothing to do with the cause of death. This just has to do with the pronouncement itself. And for some reason, organ donation was taken out in the past. And because of a timely fashion relating to corneas, it is, in other words, that's time sensitive. So the sooner the pronouncement of death is done, the sooner the harvesting of the organs can take place. And specifically with corneas, which are done in the funeral home, that can be accomplished in a more expeditious fashion. So when cleaning up that language, it was discovered, and let me take you through the section. Section 1, that in the nursing home, you could see that a PA or physician or nurse could pronounce death, but a nurse practitioner was left off, so that was put in there. And of course, the organ donation aspect was taken out. Section 2 is really what the bill was originally intended for. Section 3 is very similar to Section 1 in that the nurse could go ahead and make a pronouncement, but this added nurse practitioner, advanced practice nurse practitioner. And then Section 4, you could see where the RN could do it. Then the nurse practitioner, advanced practice nurse, and PA could be added. And that's it. This is backed by Visiting Nurses Association and so forth. I'll be happy to answer any questions.
Okay. All right. To the committee, are there any questions for the senator? Gee, no questions. Do we have anybody in the audience that signed up to speak on it? Okay. If you need to add to it.
Did they sign? Did
Okay.
you sign up? Or?
Madam Chair, I can just say, let's take petition citizen supports it. We appreciate you doing the cleanup bill.
Okay. Thank you.
I'm Stan Jones with Nelson Mullins, and we represent Visiting Nurse Hospice Atlanta. We're the oldest inpatient hospice in Atlanta. So we asked for the bill to be brought. We appreciate your support. It's also supported by the Healthcare Association, the Hospice Association, as well as the other providers of hospice services. Thank you.
Okay. Thank you. Okay. What is the committee's wish? Okay. We have a motion to pass. Do I hear a second? We have a motion to pass and a second. Is there any further discussion? Seeing none, everyone in favor of the passage of Senate Bill 96, say aye. Aye. Anyone opposed, no. The ayes have it. Don't drive too fast going home to the memorial service. Yes, sir. Senator Huffstetler, Senate Bill 47.
Thank you, Madam Chair. This bill has been actually brought to me by the Medical Association of Georgia, and in particular, a orthopedic surgeon, Dr. Brad Bushnell, who's here today as part of leadership. This is one of his projects he was working on. This is, and he travels extensively around, and I know when recently he was with the U.S. ski team in Germany, and about 20 states have put in language that lets a physician take care of their team, professional team, college team in their state. And so we've tried to mirror that language in Georgia for physicians, physician assistants, and athletic trainers. It does not allow them to write any prescriptions in the state. It doesn't allow them to work in any facility, just simply to take care of their teammates, which many of them are already doing, but they're not doing it, perhaps in a legal manner recognized by the insurance company. So we've got support from most every professional team in Georgia, most every major university, and many outside the state as well. Again, this is trying to provide this as a service to teams that come into the state of Georgia, as many of the states are providing this to us. And at the appropriate time, I'm sure he could speak to this as well.
Okay, well, let me ask you about one of them. This is a substitute to Senate Bill 47, and it's LC 337008S. And the changes that were made, we got a little bit late, were that you added physician's assistants and athletic trainers.
Correct.
Do they do that in other states, and why was this added after the physicians?
It was requested, and the medical the athletic trainers in particular said we're doing a lot of this in other states, and the surgeon said that they're correct. They do this in other states. Sometimes they may be the only one there, and the Medical Association of Georgia and this particular surgeon were okay with adding those in.
Okay. Do physician's assistants usually travel with them?
I don't travel, so maybe I better let him speak to that.
Okay, let's let Dr. Bushnell. I think you might be better able to answer the committee's question on this.
Yes, ma'am. Madam Chair and members of the committee, thank you for having me today and for giving me some of your time. Sports medicine is all about being on a team. No one doctor, no one trainer, no one PA really does all the work. We work together. So when we essentially realized we'd left out part of our teammates and their lobbyists called this to our attention late in the process of getting this through the Senate, I absolutely had no problem bringing them on board.
Okay. Let's see about the other questions. Representative Lott.
Thank you, Madam Chair. This is probably a better question for you. So we do not need to include physical therapists within this? They don't travel with the sports teams?
Not often. Most of the things a physical therapist is going to do are back home. I'm not aware of any therapists, at least at most of the high school and college levels, that travel with the team. About the only sport where that occurs is in baseball when they go to spring training, or in pro football when they're in camp if it's out of state. But none of that really applies in the state of Georgia.
Okay, thank you.
Representative Price.
Yes, thank you, Madam Chairman. I just wanted to ask or clarify if this puts any of our Georgia practitioners, providers, at a disadvantage for not being able to treat or care for people who come from other places.
Absolutely not. First of all, there's no language in here prohibiting them from helping. And second of all, if things get serious in an athletic competition and you're headed somewhere, facility, they're going to have to take over. Most of the time, the traveling team doc becomes essentially a concerned family member at that point. And again, within our culture of sports medicine, we usually, at the beginning of the game or the meet or whatever, we're shaking hands with the host physicians, kind of putting a plan of action together if something bad were to happen. So it's a very collegial atmosphere. This absolutely does not threaten most sports medicine docs' lifeblood is clinic and surgery, and it doesn't impact that at all.
So have we been acting outside the law up until now?
Well, again, this is an interesting bill in that as a physician licensed to practice in Georgia, this doesn't benefit me at all. So to answer your question, yes, I act outside the law when I travel with our kids at Berry College to Alabama, to Tennessee, to Kentucky. The two places we go where I'm not, I guess, committing a crime, if you want to call it that, is South Carolina and Illinois, because they've passed similar laws to this. So really it's the people that we host, that we invite to come with their teams, whether that be for the Super Bowl that we're going to host or the NCAA title that we're going to host. We're essentially asking them to come here and commit a crime. And that's what we're trying to fix.
Thank you.
So are you saying that Tennessee doesn't have this reciprocal?
Not yet. No, ma'am. We hope that we can shame them into it.
Well, Senator, would you like to put a clause in here that, if the states have to be reciprocal?
We've actually
I'm-
dealt with that, and while personally I would love to have that, it really defeats the spirit of what we're trying to do.
I was just being facetious, Doctor.
Sorry.
Okay. Representative Douglas.
Thank you, Madam Chair. I can speak to the validity of this bill coming forward. Actually, there has been a gentleman's code in the sports arena when you travel to another state and your player gets hurt. Taking the responsibility of taking care of that kid when he or she is away from home is very, very important. You don't want to depend on somebody else's doctor in that state that you don't have a working relationship with, even though if you need care, you don't care who's trying to give it. But in a life and death situation, I think this protects every party that has a relationship in the onus of taking care of these kids. I think it's a great bill. At the appropriate time, I would like to make a motion.
Okay. Thank you. Representative Dempsey.
Yes, I
Where
wanted
are
to.
you?
I'm right here.
Oh,
Right
okay.
here. Right here.
The guys
Good
that
afternoon.
Covered you up. She's the short one.
Now. So good afternoon to my friends down here from Rome as well. I just wanted to ask some of the other reciprocal states, and so that conversation has begun. But if you could just, how many did you say there were?
At the time we began this process, it was 22.
22. So don't
we'll be
name
number
them, but we've
23.
learned that some of our borders do not. The only ones would be South Carolina,
Yes, ma'am. That's the only one.
the only one right now. So this allows us to kind of set the example and encourage, I think.
Actually, I take back North Carolina as well.
North. Okay,
One
yeah,
little
that
part of the
little,
border
little
there.
sliver. Okay.
Tiny-
Well,
tiny
that is
bit.
great. So as someone who lives up in the corner there and who had
Right.
children who were on sports teams, I can certainly say it's very important because most of those doctors usually have a relationship. They're often a parent or an alumni of the school or have some relationship there. So I think this is a very important bill. And so, Madam Chairman, at the appropriate time, I'd like to make the second to it
Okay.
when you're
All right.
ready.
All right. And everybody else on the committee gonna have to be quiet now when these people make the motion in the seconds. Okay. Representative Hawkins.
I appreciate you bringing this bill. I have a daughter that was graduated sports medicine at the University of Georgia, and I had a good friend that sent me a picture of her kneeling over a player at the University of Florida at the Gator Bowl, and I can tell you that they helped those players. I didn't care what state they were in. But let me ask you, you mentioned prescriptive authority. There are states that allow you to prescribe from out of state, correct?
That is correct, and this bill really doesn't get into that.
Right, I noticed that. I guess I'd opened up a Pandora's box for this bill.
Absolutely, it would.
Yeah, okay.
That's really, and that's spirit and logistically, it's really not what we're trying to get at. here.
Right, I got you. Okay, well, thank you. Good bill.
Yes, sir. Thank you.
Representative Silcox.
Yes, I was just curious if it didn't say anything in particular about malpractice, but I assume that this is something that malpractice contemplates.
Essentially, at the risk of hoping there's no one from the insurance industry in the audience, I think we're a bit ahead of the game. In researching this for a white paper, the only existing malpractice case along these lines that I'm aware of is out west, when a player from Idaho, or a player from Washington crossed into Idaho, got cleared actually by a physician in Idaho to go back in the game who was not his team physician and had some pretty bad outcomes as a result. And then the question was where to sue, because it was, it took place in Idaho, but it was a relationship from outside. So if anything, that makes a case for our bill, that if you've got someone who knew that kid traveling with them, it might have ended differently. And this doesn't seek to really get into that either. All this does is just says it's a licensure exemption, so that if it wouldn't really even be that you committed malpractice. It would be simply that you were practicing without a license, which opens a different angle of exposure.
Well, that does raise the question, would your medical liability insurance cover you in another state?
Currently, it does not.
Okay, so I guess that would be the same with PAs, or, I don't know, do
Yep.
athletic trainers carry insurance?
They do, and
Okay.
essentially, we would rely, if it ever came up, upon essentially a loose interpretation of a Good Samaritan law.
Okay.
But as Representative Douglas points out, there's been a gentleman's code in our craft for a long time that wouldn't happen.
Well, hopefully there's no trial lawyers in the room. You worry about insurance, we can worry about the trial lawyers. Okay. Representative Reinders, hopefully maybe the last question.
I've got a couple, Madam Chair. Line 16, oral agreement.
Yes, sir.
Given what we've just been talking about in terms of liability and something like that, I just don't know why anybody would, if we're doing this to help reciprocate services, why we would settle for anything less than a written agreement.
That is essentially done to protect the lowest level. At the highest levels, you're going to have written agreements, which are
But
literally
if it's a
fought
he
over.
said, she said, it's not necessarily protection.
Yes, sir, you have a good point. Personally, I wouldn't get anything but a written agreement.
Right. That's good practice.
But again, I think it's probably just a way of saying a formal agreement as a recognized team physician. And in the really off chance that you had a high school traveling with a longstanding team physician who maybe never got it actually written on paper, the oral clause is in there for that.
Madam Chair, may I continue?
Mm-hmm.
Line 29, consultation. To any person residing in the state other than person in the subsection. Tell me about that subsection then. I don't want somebody consulting and potentially hurting someone that's licensed within the state because they have unlimited consulting. Right. Other than a person in this subsection.
Betsy?
Pardon me?
That's referring to the team member.
Right.
In the subsection is the team member. And then finally, if I may, line 36, a maximum of 20 additional days per sporting event may be granted upon prior request. Why would you need that?
We hosted the Olympics here once, and we hope we can do it again, or something along those lines.
And you capped it at 30.
Yes, sir.
What other events other than the Olympics can you think of?
Again, there can be any sort of, I don't want to call them atypical sporting events, but things like kayaking competitions, track and field meets, other sports that aren't just a single game or a single match. Tennis up in Rome is really big. Things like that would be covered under that clause.
Would you be agreeable to a friendly amendment on line 37 upon prior written request?
I would have no problem with that, Chuck.
Madam Chair, at the appropriate time, I'd like to make an amendment.
Okay. That's the last of the questions, so, no, we have somebody else? Okay. Which member asked, where's the list of people at the top? No. Right there. Okay, so there's nobody else on this list. Okay, we're ready. Representative Douglas.
Madam Chair, I want to make a motion that we do pass Senate Bill 47.
Okay, we have a motion that we do pass the substitute to Senate Bill 47. Representative Dempsey.
Second.
Okay, we have a motion and a second. We're ready for your amendment.
Thank you, Madam Chair, members of the committee. I respectfully ask that we scratch on line 16 or oral agreement. Or oral only, correct, thank you. And then additionally, where I'm at, line 37, upon written request, add between prior and request written.
That it?
That's it.
Okay, we have a motion for an amendment, and on line 16, it would then read corrected. The provider has a written agreement with the sports team to provide care to the team member. On. And on line 37, it would read, event may be granted upon prior written request to the board of the, or to the Georgia Board of Athletic Trainers. Okay. Discussion, Representative Mitchell.
Thank you, Madam Chair. I can easily see where a team would try to engage an individual on the spot and therefore would not have the time to get into a contractual relationship. And I think that's what the original intent was. Someone, would you be willing to come and provide these services? We need them now, as opposed to, we need your services now. Let me go get a contract and let your lawyers look over this contract to make sure it presumes all the protections you need to, and I believe that's why that would be in there and would be needed.
Are we talking about?
Line 16.
Line 16, a written and oral agreement, okay? Apparently we have more discussion about it. Representative Price.
Thank you, Madam Chairman. I'm just trying to make sure I understand who these contracts are between. Are they between the provider and the sports team, or the provider and the Board of Athletic Trainers, or what exactly?
It's a written request to the board, which would be the Board of Medicine, right? Or the Board of Athletic Trainers. The PAs would fall under the board. Is that what she's talking about, Betsy? Sorry, could you repeat that also? Okay.
Just trying to, I mean,
On line
on the front section, go ahead, Madam Chairman.
Okay. Go ahead and tell her what you need.
Yeah, on the front section, we're talking about this written agreement between the provider and the sports team. But then on the second page, we're talking about a written request to the board or the Georgia Board of Athletic Trainers. So it has to go to them as well, or only in this instance on page 2?
The page 2 thing is only if they're asking for an extension for the time, the 20 additional days. That's dealing with the board here in Georgia. On the front page, that's talking about the agreement between the sports team and the physician, PA, or athletic trainer.
So they could be asked to extend their time, but they were never asked in the first place.
Well, the team essentially is asking them to travel with them. Is that what you mean, or not following that?
If they're asking, okay, they're asking regardless if they're asking for an extension.
Okay. Senator Hofstadter, do you have something?
I was just going to say, on the front page, that is just strictly the agreement between that medical professional and the team. The composite medical board doesn't come in that case. They don't approve every single trainer in the state, or physician or physician assistant. The back page is when they need longer than the time we were allotting them. That's when there would be the request to the Georgia Composite Medical Board, or in the case of the trainer, to the Georgia Board of Athletic Trainers.
And that would all be done ahead of time.
It would have to be done ahead of time on the back page, because it says prior written request.
But only if it was that length of time would the board know anything about it?
The board wouldn't know anything about it.
Okay.
Other than that.
Okay, thank you.
Okay, Representative Newton.
Thank you, Dr. Bushnell. One of the things I was noticing on 16 and then down to 17, where it says, I guess with the amendment, we'd have the provider has a written agreement with the sports team to provide care for a specific sporting event to take place. Would that require a specific agreement with which providers we're going? Do you usually have a team that might, like 4 physicians, but 2 go to this game, and then the next month 2 go to another game?
We do. Usually we set travel schedules ahead of time.
Would that make it easier if it still had the verbal or oral agreement? Because otherwise it sounds like you need a written agreement with every specific sporting event. Is the way I'm reading it. When I take the oral out, And I thought that the flexibility of sending one or more members of a team of medical providers.
Who understands the importance of good liability insurance might understand where I'm going. In the medical profession, I'm a fan that crosses T's and dot I's, as opposed to putting someone in a libelous position.
I'm sorry. Is that something Betsy could answer, or?
I would speak to that just to say that while I personally would agree with you that it's always better if you do it in writing, we have the oral in there to, as Dr. Newton points out, to make it a little more flexible, because the reality is that a lot of sports medicine coverage, especially at the high school level, is very informal. I'm not saying I would do it that way necessarily in every case, but that's just the reality of it.
Representative Lott.
I was actually going to ask a similar question, but I'll kind of go with this still. So at the high school level, if we do take the oral out and you have a physician that might also be a team parent and they tend to travel with the team, if we take oral out, we've now got to figure out how to get them contracted, right? Correct. Get some sort of written agreement with them. And also, I guess on a second question, but the same, if we remove oral, I have a concern when a medical facility has the athletic trainers, the physical therapists, the PAs go to the football games. Does each individual employee beyond have to then have a written agreement when we have actually a written agreement with the medical facility and they kind of farm out those the medical personnel to different games? I'm afraid if we take oral out, then we're going to get into a little bit more of a bind with some of that. There was not really a question there, was there? What do you think?
I would agree with that. The reality is that while definitely within our profession we recognize that written is best, I would not argue that point at all. But the reality of the sports medicine situation is much more fluid, that a lot of it is done on handshakes, and that we probably do create a lot more work for our composite state medical board if we make it written.
Okay, Representative Sharper.
Thank you, Madam Chair. Over my 25 years of being a parent and going to different places, and we've been in this situation where I've helped out, and I know that I was covered basically the Good Samaritan law. But I will say this: I agree with the written just because we can do oral as long as everything is good. But when something happens bad, you have nothing to stand on. And in the medical field, if you didn't document it, it didn't happen. So just like an oral agreement, if it's not written, it really didn't happen when something goes bad. So I feel that there's nothing wrong with the written, and if a person is in that situation, like Representative Lott said, that they would be covered, I think, in a Good Samaritan situation. So I agree with the written because, like I say, oral doesn't hold up in court either.
Senator Huffstetler, it's a good thing you didn't say this was just a simple little bill to start with.
Right.
Representative Douglas.
Thank you, Madam Chair. Let me speak to what they're trying to get to here. They're trying to cover all bases with this bill. The latter part on 16, the written is easier to do at the professional and the collegiate levels, because you have a set doctor that's set there that represents that team. And also on the collegiate level, there's a set doctor that goes, but on coming down the tier, when you get to high school, you have a group of doctors in that area that disperse throughout the week on which way they're going. And all the times they don't know which way they're going, because they cover probably, it's 5 doctors, they cover 3 or 4 teams in that area. So they are able to go either way based on who's going where. That gives them some type of clarity or option of them not getting a written, because if I don't have a written statement going to this game, then I can't go. But if I'm going to another game, I still have to get a written, and I may not be going to that game. I don't know if that makes sense, but It's just to clear up the lower levels.
If I may, Madam Chair, not my first rodeo seeing teams come in from out of state. And usually, as you know, those schedules and those tournaments, whether it's the Beach Ball Classic in Myrtle Beach, whether it's Leon from Tallahassee coming in to play a game, as you know, those are not contracts that are made in the last 2 weeks to fill a spot. These are usually high-profile games, high-profile tournaments when we're talking about people coming in from outside. I will also say that in covering local softball tournaments and things of this nature, usually there is a deadline before the team has to even have an agreement to come and enter into the tournament. They don't just show up on a Thursday to play a doubleheader on Saturday and one on Sunday and go home, even on traveling teams from out of state. Would you disagree?
Now that depends on, no, I don't disagree, but then I don't agree either, because the simple fact.
Good answer. Good answer. For most of these teams, they've signed contracts well in advance, Madam Chair, and all I'm trying to do is take away the if factor if something goes wrong, and that's it.
Okay. Representative Hawkins.
I just speak against the amendment respectfully. I just, having a daughter that's done this, sometimes you're lucky to find anybody that can get there on a certain night. I think that I'm listening to a physician who's been doing this for some time. They're just trying to make this a workable solution, and I think we ought to be good with the bill the way it is. Not send it back to the Senate.
Okay. Okay. So, Representative Silcox.
I was just going to say that I think that this can be resolved. I think we could leave the bill the way that it is, but we could just encourage y'all to make contracts in advance with all the teams, be it high school, college, or professional teams in advance that contemplate all the people that could be participating, the trainers, the PAs, everybody by name, just to Representative Reiner's point that, then you're covered. These are all the people that may be at the games for the season, and that way we don't necessarily have to amend it unless y'all want to. But I just think it's a good practice from a malpractice standpoint.
Representative Mitchell.
Not to be redundant, Madam Chair, but I do believe that to be the case as well. I just looking at the class of providers that this would cover, they have a duty to perform when their services is needed in any event. I can't imagine a situation by which their services are needed as a provider and someone were to say, sorry, I'm not under contract. So I think this flexibility is needed.
Okay. Last question. Representative Sharper.
Okay, thank you, Madam Chair. I'm just thinking that there is a way that they can have the written in advance, almost like a medical director, meaning it can be done that way with the written. So I'm just going on record as being in favor of the written.
Okay. All right. I guess we're making a decision between hopefully the Good Samaritan law holds, or we're giving extra cases to the trial lawyers. So anyway, here we go. Are you a trial lawyer, Senator? No, ma'am. Okay. I just got that big grin. I thought maybe you were a trial lawyer. Okay, so I'm going to break.
Madam Chair, would you prefer me to do these in one at a time?
Yes, that's what I was going to say. I was going to break it up.
All right. Madam Chair, I move that we scratch on line 16 or oral.
Okay.
I look to my friend Representative Sharper for a second.
Okay.
I knew he was reading
Will
I knew he was reading the rest of the bill.
Right, exactly.
Representative Reinders, are you taking over my committee?
No, ma'am, I just heard him speak in favor of it.
Oh, that's okay. So we have on line 6, the provider has a written agreement. We have taken out our oral. So everyone in favor of removing our oral from line 16, hold up your hand.
Yeah, there's a flaming out.
Everyone against? Everyone against? Okay, I mean, I'm afraid that amendment fails. Okay, Representative Reinders, I'll recognize you for
Well,
another one.
based on that, I'm scared to go here. Oh, you're gonna help me here? Yeah, I'm with the government. I'm here to help you, right? All right, what have I got here? Help me. Where was I at?
You're on line 37.
Line 37 may be granted upon written request. And that, my understanding is, unless Betsy wants to give me some clarification, that that would be with the Georgia Board of Athletic Trainers, so we wouldn't get that spur of the moment kind of gotcha that everybody was scared of on the last amendment.
Either the composite board or the Board of Athletic
Right, right.
Okay. All right, so we have on line 37, event may be granted upon prior written request to the board. That's the proposed amendment. We need a second. Do we get a second? Okay. All right, and everyone in favor of Representative Reinder's second motion, say aye. Anyone opposed? No. No. Oh.
That was a clear aye.
Okay, that was, all right. Here we go again. Everyone in favor of putting in written before request to the Board of Medicine or the Georgia Board of Athletic Trainers, hold up your hand. This is favor.
Just raise it, Matt.
Everyone opposed? Do likewise. Raise your hand. Okay. The amendment passes. All right, so our status now is that we have amended, and we have a motion on the floor of do pass. Everyone in favor of the passage of substitute to Senate Bill 47 as amended, say aye. Aye. Anyone opposed, say no. The ayes have it. So, Senator Hustetler, and thank you very much, Dr. Bushnell, for coming.
Thank you for having me.
Thank y'all. Thanks a lot.
Don't bring any more simple little bills, Senator
trying to.
Hustetler. Yeah, no, all right. Okay, Senate Bill 109 by Senator Williams.
Thank you, Madam Chair, members of the committee. Hopefully we have a very common sense bill here before you. The bill, it creates an interstate compact that would allow for emergency service personnel to operate in states that have signed on to the compact, basically in instances where the governor has declared a state of emergency. It would allow the EMS people to come in and help out in those cases, as well as if they're transporting patients to or from their home state to the current state. And it just goes and it sets forth a commission that will oversee it and some other details to it. But that's the basic gist of the bill. It just allows for EMS people to come in and help out in case of emergency.
Okay, questions for the senator? So what you're saying, this is strictly for emergency situations or when we're having somebody from Georgia transport somebody to Alabama or somebody from Alabama, if they had the same kind of reciprocal.
Correct.
To
Correct.
come
If
and
it's a state that
transport a
has
patient
this.
to Georgia.
Yes, ma'am.
So it's not for licensure in our state.
No.
So if they wanted to be licensed in our state, they would have to go through our process, meet
Correct.
our requirements.
Yes, ma'am.
Okay, so in that way, it's sort of different from some of the compacts.
Yes.
And I have one more question before I take questions. I was reading that you needed 10 states
10
to go
states.
along with. Where are you
We
on
have
that
8
road?
right now, and Tennessee is considering it as well as Georgia, and we're hoping that Tennessee passes it first so we can be number 10 and get all the fame and glory.
And what is the cost to the state?
It is very minimal. The only cost would be sending the commission. We have a single commissioner that would sit on the board, and travel that would be associated with that. Outside of that, there's no cost to the state.
Okay. All right, now for questions. Representative Sharper.
Thank you, Madam Chair. Just at the appropriate time, I would like to make the motion that we pass this. As a paramedic for 25 years, we need this in place, and I've had to go to Florida and Alabama in the same situation. So.
Well, and, you know, let me ask another question. If you're just transporting somebody over state lines, why would there be a problem with this? in what case would you need it?
It just gives
I
them.
know the answer, but I'm just trying to let you tell my committee.
You want to answer that one? I don't want to mess it up.
Okay, and you are?
Madam Chair, my name is Ernie Doss. I'm Deputy Director of the Georgia Office of EMS and Trauma.
Okay.
So where this bill would help out, it would give immediate legal recognition to medics who are licensed in other state when they're called to our state. So the most recent example I could give is when we had the wildfires in North Georgia. We had, that was a declared emergency, and we had paramedics, firefighters coming from all over the country that we could not legally recognize as paramedics on those fire crews. This would allow those folks to be recognized at that time, and they could serve as paramedics with those crews. We can transport people out of state all day long without this compact.
Okay. But this would allow, if you were transporting somebody to Alabama and there was a car wreck in Alabama, could our EMS and emergency personnel stop?
This would allow them to, yes, ma'am, I'm sorry, I didn't mean to interrupt you. This would allow them to stop and render aid to the full level of their ability without getting in trouble with anybody else's state laws. Yes, ma'am.
Okay. Representative Silcox.
First of all, I want to thank you for bringing this bill. I met some of the firefighters in North Georgia when I was up there this fall, and some of the guys were from as far away as Arizona, and just really appreciated them coming so far to save our forest in North Georgia. But second of all, just a question. My understanding is that unless it's declared a federal disaster area, that the Red Cross cannot come in. Is that correct?
I don't know the answer to that, ma'am.
Okay, because I think this is needed for that purpose. My understanding is if it's just a local disaster, but it's not a federal disaster area, then the Red Cross cannot come in.
And I appreciate your comments, but in my reading of this, it doesn't address the Red Cross. It only addresses.
No.
Yeah, it just
But that's why
addresses
it's
those that are
needed, is what I'm
licensed, and it
saying.
gives
If it's
them the
just a
ability.
local disaster,
Yeah.
it is needed, because the Red Cross cannot come.
I'm not sure that that's exactly true. It seems like we passed something years ago that in reciprocal states, our Red Cross emergency teams could go there or they could come to us. I think it was requested by the Red Cross. You'll just have to check the law and see that, because they think there's a fault starting up around Memphis, Tennessee, and that we're going to have a great earthquake, and that's going to come down across Tennessee and Alabama and down to North Georgia, and so they wanted that ability to go places. I think it was passed about 1998 or somewhere like that. I was the author of the bill. I don't remember exactly if it had to be in there that it was the federal. It's been too long, but I don't remember it having to be declared a federal disaster for it to happen, unless something's come along afterwards. Representative Reinders.
Thank you, Madam Chair, and I like the bill a lot, coming from what's recently happened in Southwest Georgia. I just want to make sure, though, because it's a lot to read, does this have to be a declared emergency by the governor?
Yes.
And is the length of time of which this reciprocation shall take place only during the time of declaration?
If you
So
look
once it's
on line 165, upon a member state governor's declaration of a state of emergency or disaster that activates the Emergency Management Assistance Compact, all relevant terms and provisions shall apply to the extent any terms of provision of the compact. So basically, yes, they're only in the event of.
And then I also assume that as soon as the declaration is over,
Correct.
then it's no longer in effect.
Yes, sir.
Thank you, Madam Chair.
Okay, Representative Price.
Thank you, Madam Chairman. I just had questions about the commission that would be activated.
Sure.
And is there a fiscal note that goes with that, or is there anything in the budget that is necessary for that?
There is no fiscal note. The only cost to that would be the travel for the one member of the commission to go to their meetings and talking with other states and people that are driving this. There'd be no more than 2 meetings a year, and some of those can even be remotely. So the impact of this is very, very minuscule.
But still, who would pay for it?
So, Madam, the National Registry of EMTs is funding the cost of the compact for all the member states, and so the cost to Georgia would be negligible or minimal. And in the event that the National Registry decided to remove or reduce their funding, Georgia would have the ability to opt out at that time, or at those times.
Yeah, somebody hit the lights. Nah, I guess. Either that or we wanted to be in the spotlight. Representative Barr. The other way, John. Okay, well, whatever. Representative Barr.
Thank you. I too have a few questions on the commission. So the actual commissioner for Georgia, does that automatically fall to someone?
I believe it
Page
would.
is
It would be the Stadium S director.
Okay. Follow up.
Yes.
On 316, it starts talking about the commission shall have the following powers. And it all the way down to the last line, to borrow money. And then we move over 356 to assess annual fees for each member state. Can you talk to me about the seemingly vast powers that this commission will have?
Well, first of all, on line 341, to borrow money, if it borrows money, it does not put any of the member states at risk. So it would be debt that the commission would be responsible for, not any of the other member states. And then where did you see the, as far as assessing fees?
356. Commission may levy fees on and collect an annual assessment from each member state.
Yeah, or impose fees on other parties. Right now, they're only planning on imposing fees upon the
National Registry of EMTs has agreed to fund the compact, the cost of fund of the
So this
compact.
doesn't obligate our state?
Does not obligate our state.
Okay.
Is that all, Representative Barr?
Yes, ma'am. Thank you, ma'am.
Okay, that's all the questions. So, let me see who, Josh Mackey, you wanted to speak on this?
Thank you, Madam Chair. My name is Josh Mackey, representing the Georgia Association of EMS, and I have Captain Nick Adams with me from Cobb County Fire. He's on our board and chairs our legislative committee. He's also been involved in this legislation. We want to thank Senator Williams for bringing this. This is a bill that the association has pushed. In addition, it will benefit all of our personnel and also benefit to have the State Office of EMS on this compact. I think most of the questions have been answered. I'll let Captain Adams make a statement. We can answer any other questions that may arise.
Okay, Captain Adams, welcome.
Yeah, thank you very much. I'll be brief. I do sit on the board of directors for Georgia Association of EMS. We do support this bill. Like the senator said, I believe it is, the representative said, I believe it is necessary, something we've been needing for quite some time. Like the representatives, the senator has alluded to, it would allow us not only to cross borders to assist our member states or sister states, but it will also allow those states to come in to assist us when necessary. So we do fully support this bill.
Okay, do we have any question? Well, we do. Representative Sharper.
I was just ready to make the motion whenever we get ready.
Okay, is that it? Who's this? Representative Price.
Thank you, ma'am. On line 233, or 232 and 233, where is the principal office of the commission to be located?
I believe it's going to be at the headquarters of the National Registry of EMTs, which is in Illinois.
It's in Columbus, Ohio.
Oh, Columbus, sorry.
It just seems odd to me that we are in Georgia law going to establish an interstate commission of which we don't have authority over. I'm just trying to sort this out.
Representative Price, we've got other compacts that are being proposed, and like the nursing compact is run out of, is it New York? Leo's not here. Yes, you are. Sorry, Leo.
But
Right beside me.
are we establishing it in Georgia?
If we pass a compact, we will be. We'll be joining a compact. That's what y'all are doing, right? Is
correct.
If up 10 states, they will be joining a compact.
And also, Currently, the state of Georgia uses the National Registry of Emergency Medical Technicians. That's kind of what they use as the standard for the EMT training and managing and supervising the EMTs and EMS members here in the state. And this compact uses that same organization. So we're using the same group of people, the same organization to manage and to police the state as far as it goes to.
So if that's already set up, what is the necessity for the commission?
Just to oversee it.
As the senator was stating, the National Registry of EMTs is our licensing testing service that 48 states use. So that allows this to be an easier mechanism to establish a compact. And frankly, it's why it's not as controversial as other compacts. But the aspect of the compact that's going to benefit our personnel here is what's been stated, which is we're going to be able to go across state lines in those emergencies and provide help without any legal ramifications for the personnel. Or, for example, if somebody's in Ringgold taking somebody to Erlanger Hospital on their way back, they can stop at an accident on I-24 without legal ramifications.
I understand the purpose. My concern is, are we establishing something that's then going to become a behemoth that we have to feed?
I don't believe so, simply because every person that's on the compact commission, you know, as Mr. Doss stated, the director of the State Office of EMS, he's responsible to the Commissioner of Public Health and the governor. He can't agree to anything that the state of Georgia and the executive branch doesn't want him to agree to, such as Representative Barr's question and the assessment of fees. The National Association of State EMS Officials have agreed that they're not going to assess fees on any states. If the compact entity ever wants to do that, then I think we'd end up back here at the legislature trying to repeal this compact, and I think there would be a number of other states that agree to it. So I think everybody brings that same perspective.
And also, if you'll look on line 585 and 586, it states that nothing in this compact supersedes state law or rules related to licensures of EMS. So even within the compact, it still gives the states the ability to oversee, again, that their EMS. So
I'd like to add to that, in 569, it also gives any member state may withdraw from this compact by enacting a statute repealing the same. So we do have an opt-out clause.
So it becomes a behemoth, which I don't think it will, but we can simply opt out.
Okay. All right. You finished? Through? Okay, things like that. Okay, is there anybody else that would like to speak to the bill? All right, no, we don't have anybody. Thank you very much.
Thank you.
All right. Representative Sharper, you're recognized for a motion.
I'd like to make a motion to do pass Senate Bill 109.
Okay, you have a motion and a second. Is there any further discussion? Seeing none, everyone in favor of the passage of Senate Bill 109, say aye.
Aye.
Anyone opposed? No. Okay, we have the ayes have it. Thank you very much, Senator.
Thank you, Madam Chair, members of the committee.
Where are we going next? Okay. Okay. Senator Rett, Senate Bill 202. Senator Rett, let me just be clear with you from the beginning. This is a hearing only because I just got the fiscal note on the bill. And, you know, to pass the law, I think we're going to have to look at it a little bit more closely. So, but I wanted to get started so that we could get this heard, because you certainly have a proposal that would affect a lot of people, and God forbid that any of us ever find ourselves in the position of the people that you're trying to help. So go ahead.
Yes, ma'am. Thank you, Madam Chair. Basically, this bill would ask the Department of Community Health to modify the state plan for medical assistance to increase the personal needs allowance for people who are staying in nursing homes. personal needs allowance comes to toiletries, toothpaste, things of a personal nature that people need, whether they're in a nursing home or not. Basically, the last increase was about 10 years ago, and it hasn't quite kept up with inflation. So we're talking about trying to increase it from $50 to $70. This bill unanimously passed the Senate Health Committee. It unanimously passed the Senate Chamber. Everybody voting in favor for it. It's supported by the Georgia Health Care Association and the Georgia Council of Aging. And just give you a little background, one of the reasons I came up with this bill, some of you know I served in the Air Force for over 30 years, and currently I'm an officer with the American Legion Post 296, and about 4 times a year we go and raise funds to collect toiletries and put them in packages and go to the different nursing homes to try to assist people in their personal needs. And that's pretty much how I came up with this bill. And I work in conjunction here with my buddy.
I'm Josh Mackey again, representing the Georgia Healthcare Association for Skilled Nursing and Long-Term Care Facilities. Senator Rett brought us this bill earlier in the session. We're very supportive. We think there's a need to it. There is a fiscal impact, which is why in the bill it's subject to state appropriations. I believe it's a $2.2 million impact, but we do support the intention of it. And going forward, obviously, we're late in the session in the budget year, but we are going to actively support future appropriation for this if the bill is passed.
Okay, so this. Okay, and the report that I got, or were you finished, Senator?
Oh, you can go ahead. I'll wait till you finish.
No, that it would be a $2.2 million cost to the state.
Yes, ma'am. Yes, ma'am. That's correct. Approximately $1.6 million would come from the Department of Community Health for Medicaid non-SSI recipients, and approximately about $600,000 from the Department of Human Health Services for Medicaid SSI recipients. That's in the third paragraph, probably the last 2-3 sentences, the third paragraph.
Okay, explain to the committee exactly who gets this money and their status.
Basically, it goes to, a certain amount of money is allocated through Medicaid to the nursing homes, and then the personal allowance amount is deducted from there for the individuals for their individual personal needs. Did you want anything?
Okay, so basically the poorest of the poor in our state that find themselves
Yes, ma'am.
Like that. And how much is the amount now?
$50. The last time it was increased was 10 years ago. And we're looking at perhaps an incremental increase or maybe going up to 70. We left that open.
Okay. All right, we have questions. Representative Silcox.
I was just curious, did you have any studies to indicate what would be the correct amount? I know I helped care for my grandmother in this situation before she passed away, and her expenses were substantially, her personal expenses were substantially more than this. And I'm just curious if you had any data to substantiate $70.
No, ma'am.
Okay.
Was this just based on the fact that they hadn't had a raise in 10 years and
Right.
a minimum amount of?
Just to answer your question, basically it comes down to the personal situation. Some people have other forms of insurance to support them. But we wanted to try and get something into the budget that wasn't a significant increase, but enough that when we went to the Senate budget person, Senator Jack Hill, he liked that amount and he was willing to work with us so that we were able to come up with this bill, because this is based on Medicaid money.
Representative Reinders.
Thank you, Madam Chair, and I want to talk about the budgetary process in just a minute, but I beat this drum on more than one occasion. I would remind the committee, especially the newer members, Madam Chair, we've had this before. that term upon state appropriations. That came up a couple years ago, and next thing we knew, we were being accused by certain members of not funding something, even though we recognized there was a problem. So I always offer a lot of caution to trying to understand and give the recognition that a problem exists, but at the same time not being used as leverage for us not appropriating because we have to make tough appropriations decisions. And I remember that an awful lot. Now let's go back to the budget process. Why wouldn't this be as simple as, since you've got the 18 budget, why wouldn't this be as simple as you going to Chairman Hill and doing something with the budget in the Senate, since y'all have the budget now?
Well, we got started a little bit late on this, and we went and talked with them about.
Why is a bill needed instead of just an addition in the budget?
I'm sorry, say that.
Why is a bill needed instead of an additional line item in the budget?
This is the route we thought it was best to proceed with. But we're open to suggestions.
I'd suggest you get Senator Hill.
Josh, did you have a reason for thinking a bill's the best way to go?
So when Senator Redd brought this to us, obviously that question came up, and we agreed to support a bill because we feel that it at least puts it on record. It doesn't hold you to it.
Well, that was
I mean,
the first part, you put us on record, and
well,
then we
it puts
don't
it on
fund
record
it.
that everybody thinks an increase should take place. I think, as Senator Redd has stated, it's been 10 years, and while there hasn't been a specific study into the amount, I think moving it up to $70 would be a good commitment to help cover some of those inflationary aspects. This is used for when residents, do their hair or things like that.
Okay.
Thank you, Madam Chair.
Okay. Representative Hilton.
Chairman Reinders stole my question. It's a good question.
Okay. Representative Mitchell.
Thank you, Madam Chair. I presume that you brought the bill because they're spending $50 now, and you felt that amount is inappropriate. But to my question is, what are considered personal needs that this money would go to?
So it's really more in terms of a discretionary spending on everyday things. Obviously, there's some more basic needs for like hygienic products that are already covered, but this is more, like I said, for somebody who wants to, go to the beauty salon in the facility or have their hair done. There's more discretionary items that are day-to-day common for all of us, that are a necessity for a person to, be more vibrant in their life.
We've got some members here who say they don't spend $50 a month on those.
Well, it wouldn't be for just that single
Oh.
item. This is an allocation for every little thing they may need.
Right. Thank you, Madam Chair.
Representative Silcox.
To Representative Reiner's point, I really would like to see some data on this. I really would. I think that this is maybe setting us up for one of those gotcha opportunities. And just as a new member of this body, it makes me nervous without any data.
Okay. She waved. Okay. I think that's all the questions from the committee. Do we have people that want to speak on this bill? No one? Okay. Yeah.
Move to table, Madam Chair.
Okay. We have a motion to table and a second to that. Is there any discussion about a motion to table? All right, everyone in favor of tabling Senate Bill 202, say aye. Okay, wait a minute, let me back up on that. Representative Mosby? Well, Representative Mitchell?
In as much as this is just a hearing only, does it require us to table it in any event? Because it's not going to get a pass from the committee today in any event.
Well, probably doesn't, but just on special measure, we'll go ahead and table it, and it can be taken off the table.
You don't think I asked before I did it, do you?
He's just getting on it. So, okay, everyone in favor of the motion to table Senate Bill 202, say aye. Anyone opposed, no? Okay, the ayes have it, so it's tabled. If you can bring us some statistics or a compelling need for us to do this instead of going to via the appropriations route, let us know and we'll see you back. Thank you. Thank you. Okay. What do you need? Yeah. Representative Raystraw.
Thank you, Madam Chair and members of the committee. What I bring before you is House Resolution 447, and this is a bill that has passed in several states that declares pornography a public health crisis. And we have a lot of testimony and sworn statements by people that have been impacted and affected negatively by this that I want to get our committee aide to pass out. I think we only have 8 copies, so y'all may have to share, and it's a lot of information, but I want to enter it into the record to support what we're talking about here. And I have Chris Severe and from Tennessee and some other experts that I wanted to, well, we have a medical expert that deals with mental health and sex addiction and some other people that I wanted to bring up to speak, but I'm going to turn it over to Chris and let him speak to you more about this. Okay.
Hey, Madam Chairman, thank you for having us, and thank you, committee members. So if I can, before I'm going to tell you about this bill and how it came about and things like that, but I want to first say that this bill has become law in the state of Utah. It passed the House, the Senate. The governor signed in April of 2016, which made national, basically almost international news, because it reframes the question of pornography as just a moral question, pornography online, and as one of a matter that impacts mental health, reproductive health, sexual health, emotional health. And the resolution is also passed unanimously in Virginia through the House. It's passed through South Dakota Senate. And, it's without apology that we have this resolution being introduced in 42 states right now. And we also have another bill that relates to it called the Human Trafficking Prevention Act. So what the resolution does is it identifies the problem, and the solution is found in this other companion bill. So if I may, Madam Chairman, I'm going to give a background about how this bill came about. Okay, yes, ma'am. So I went to Vanderbilt undergrad. Vanderbilt Law School, was in the United States military as a judge advocate general, deployed to Operation Iraqi Freedom, was almost killed by insurgents in Iraq and Mosul. And it was from that experience that I decided that henceforth I really wanted to be involved with Christian-related matters and just a personal choice. And I decided to become an overseas Christian missionary. And I started going on all these overseas Christian mission trips, and I started noticing how bad human trafficking was a problem overseas. And I ended up joining FBI groups, working with special forces to do extractions overseas. And that, led me directly into the fight against human trafficking. And basically what we were seeing is the intel shows conclusively that cartels were moving away from drugs, especially as it's becoming more legalized in the United States, and shifting more into fighting human trafficking, because it's a commodity they can use over and over again. And also, I came to terms with the fact that pornography online was playing a huge role in this kind of seamless continuum where you have strip clubs, prostitution hubs online, you have pornography connected to drugs, and this is one seamless continuum. And so what I decided to do was instead of kicking in doors and trying to prosecute kind of our way out of it, I started to think that we should make prevention the first response. And so I began by filing lawsuits against the major tech companies. I started with Apple. We filed a federal lawsuit against Apple in the Middle District of Tennessee, saying that the current condition that they sell their products in is dangerous and defective, effectively saying that they're violating product liability codes and they're violating the Lanham Act. And they market their products as being family-friendly when we all know that they're not. They're loaded with pornography. And so in suing Apple, they kind of made the argument that the reason they don't comply with state and federal obscenity codes is because none of the other tech companies do either. So then we sued the rest for racketeering and obscenity, sex trafficking, false advertisement, products liability. So it was Google, Microsoft, Verizon, Dell, HP, all of them hauled into federal court. And we made them make their best arguments for why they should not be regulated. And they were never able to get around the Supreme Court precedents that we were relying on. And so what happened from there is that led to meetings in D.C. where the federal legislature was seeing that we were legislating through the courts, because that's exactly what we were doing. And we decided that through meeting with members of the Senate Judiciary Committee in D.C. that what we needed was state legislation that paralleled the existing state laws that would regulate the tech companies in a manner that accords with First Amendment heightened scrutiny standards. And so we've rolled out, along with this resolution, a bill called the Human Trafficking and Child Exploitation Prevention Act, which basically pulls from the existing obscenity codes. And it basically says, just like in Georgia, if you have a gas station or a 7-Eleven, or a newsstand, you can sell a Rolling Stone magazine next to a hunting and fishing magazine, next to an SEC football magazine, next to a Playboy and Hustler. But the Playboy and Hustler have to be behind a blinder rack, some kind of opaque covering that makes it to where by default that material is blocked out. And we really want the filter law to be a state law, first of all, because we want the state courts to have jurisdiction. We're relying on state obscenity codes. And some of the one of the obscenity codes we rely on is the idea that, why is it that a 12-year-old in the state of Georgia can't go see an R-rated movie, but they can walk around with a filterless, they can walk around with an X-rated theater in their pocket in the form of a filterless iPhone. So anyway, I just wanted to give some of that background and say without apology that the resolution is connected with another bill. This resolution effectively identifies the problem. It's kind of like saying that radical Islamic terrorism, radical Islamic ideology is proliferating terrorism. And so it's one thing to identify it, and then it's another thing to solve it. And so, this gets folks not only in government thinking about it maybe in a different way, but also the public too, to say we're not just trying to we're not legislating morality. We're basically just wanting people to this resolution promotes awareness that if you interface with pornography on these products that distribute the internet, it can impact your mental health, it can impact your reproductive health, your marital health, your emotional health. And so this is the step that identifies it. And then the filter bill that we've had, all the states introducing as well, state and federal, is the sound solution predicated on Supreme Court holdings in a case called Ginsburg and Ashcroft. And, the state has a compelling interest to uphold community standards of decency. The Supreme Court's found that over and over. The Supreme Court's found over and over that there's secondary harmful effects. And so this resolution is a step that can be taken to help us then be able to regulate these matters in a way that's more digestible. And, there's been an explosion in human trafficking, child exploitation, there's, sexual exploitation, domestic violence, things of that nature. And it's very much going hand in hand with easily accessible pornography online and easily accessible prostitution hubs online. And it is the case that, people should have the fundamental right to choose stupid, so to speak. But it is the case that the legislature of this state should engage in a manner that would make the objective healthy choice the easy choice. And so the resolution will help call attention to that and help frame it in a manner that's palatable. Even when Utah passed the resolution, the New York Times released an article that said, it's okay, liberal parents, you can freak out about pornography. And so that's some general background. We do have 35 sworn statements. Unfortunately, we have a cheat sheet here that's got a list of who all has provided testimonials in these cases, and we have 33,000 testimonials provided by Fight the New Drug. Fortunately, we only printed out about 1,000 today, and those are testimonials from minors who have reached out to this organization saying, I didn't know that interfacing with pornography online was going to be so bad for me, but they are attesting that it's really impacted them emotionally. It's created all kind of different kind of addictions, pornography addictions. And so we have all these we have actually former survivors of human trafficking who are attesting that pornography is connected with human trafficking, and they link the two together. And I'm glad to kind of summarize their testimony if that would be helpful. And then we have all of these groups that have propped up to fight human trafficking and fight pornography, and our other bill will go to help enable and finance a lot of those groups, and it's going to do a whole lot of good for the public safety, health, and welfare of the state. And we have a lot of tech experts we've relied on, all these government officials, and we have 9 mental health experts we've relied on that provide all this testimony that pornography hurts dopamine, oxytocin, beta-phosphate, serotonin, that it adversely, alters the reward cycle and the limbic system. And basically, folks can use pornography just like they use opioids, or they can cultivate a gambling addiction to try to satisfy some emotional need, to deal with emotional challenges. But it has the same effects of, other drugs in many ways. It impacts the brain in the same way, and it can lead to all kinds of secondary harmful effects and criminal activity. And, by identifying this, we can make people think twice before they interface with this content. We've interviewed so many folks that have been arrested for prostitution or human trafficking, and they have the same narrative of, they just wish it wasn't so easily accessible online, and it wasn't just kind of promoted as it's something that's normal. I mean, pornography can definitely be used to normalize false permission-giving beliefs. It can be used to erode consent. It's used very often by the Johns to do grooming of the girls themselves. And so for all of these reasons, there's good reason that for decades now it's been declared as unprotected harmful speech. And there's absolutely no justifiable reason for the tech companies to distribute this with complete immunity and just wreck families and pretend like it's the user's problem. And so this resolution really will be an affirmative step to help proliferate the public health in the state of Georgia.
Thank you very much.
Yes, ma'am.
I have to say that Senator Unterman in the Senate has certainly been a leader in the sexual exploitation of minors in the state, and has done a lot of work on it, and certainly spoken about it and been a leader in trying to get other states to do that. I'm a little surprised that this didn't start over there, but at least it started over here. So we have some questions from the committee. Representative Reinders.
Thank you, Madam Chair. I want to first ask a technical question on line 31 is a public health crisis. Is that using that particular phrase? Does that have any kind of significance in terms of funding or recognition, anything like that?
That's significant in terms of recognition. In terms of funding, I don't think it necessarily triggers anything, but the representative would speak on that.
All right, thank you.
No, this bill, in and of itself does not trigger any of the funding.
Well, I didn't know if
do
you had to
have
be
some-
designated a certain so-and-so in order to be eligible for something else.
Sure.
No,
And
it's
that's
just
not
to
the case.
raise awareness of.
And finally,
this
my
being a public health issue.
understanding of the Supreme Court definition of pornography is community standards. Would you agree with that?
Well, I would say the Supreme Court has said, first of all, they had, let me just back up and say, Apple was the one that always would make the argument that one man's art's another man's, one man's lyrics, another man's vulgarity, so to speak. And so there was a big debate of how do we define pornography. And so we would, we'd often point to the simple Supreme Court decision that, I know it when I see it, which is what kind of like
Okay,
sorry.
I
go ahead.
appreciate it.
Yeah.
You give me your opinion of what the Supreme Court opinion's definition is.
Well, I'd say the Miller standard is pretty clear, and then also
Which is?
Which it's I don't think I can off the top of my head tell you what it is, but I can say this. I can say the ignorance of the law is no excuse, and I'd also say that the state of Georgia has clearly defined what obscenity is in the statutes exist now. And also in the federal government, under 18 U.S.C. 1460, they too have defined what obscenity is. And so it's pretty...
Okay, I'm sorry. Let
Sorry,
me
go
get in the
ahead.
weeds a little bit more.
Sure. Yes, sir.
And no one defends it. It is one of those I know it when I see it kind of things to a certain extent to
Right.
some people. And so if I can't get agreement on your definition of what the Supreme Court has said about this, because my understanding is, and please correct me if I'm wrong because I'm not a legal expert, but that if Buckhead wants to have a club here and that's their community standard, even if I don't approve of it,
Right.
then that's okay.
If you're talking about a strip club, for example?
If you want to use that as an
Yes,
example,
so
sure.
if someone
But
wants to...
please.
Sorry. Yes,
But if it doesn't happen in another community, the same strip club, same owners, then that can be their community standard. Is that correct?
I mean, you're dealing with zoning ordinances in that case. So the state of Georgia would say that you can build a strip club in the state of Georgia if you want to, but it's okay for the state legislature or the cities in some cases to say, but you're not going to build it near, a school. You're not going to build it in the middle of the suburbs. We're going to zone you to the side of the highway or somewhere that's hard to reach. And so it's regulating the time, place, and manner of unprotected harmful speech that has secondary harmful effects.
Okay. Regulated in time, place, and manner.
Mm-hmm.
Okay.
Not prohibited. Yeah, sorry.
Thank you, Madam Chair.
Okay, Representative Henson.
Thank you. You talk about getting this out to the public. How do you plan on doing this? I mean, we have a resolution here. There's nothing that says to urge or encourage the Department of Public Health to do anything. We passed this. There might be an article in the newspaper. There might not. We don't know. So I'm sort of curious. And then you also talk about another bill. And I haven't seen that other bill. I know nothing about that other bill, but I'm going to guess that other bill is going to cost money.
The other bill makes the state of Georgia $66 million annually, we predict. So the bill is, I'd have to break down what that bill is. I'll be glad to do it if that would be helpful. But it's not something that's very simplistic. It's
Where
taken
is the other bill?
The other bills they had a hearing today in Judiciary Committee, and go.
So that bill's not moving this year. There's actually 3 bills. There's the Human Trafficking Prevention Act, and basically it takes our existing laws that require that pornographic content be behind a blinder rack to protect children and people that are underage, and it applies it to the internet. And it basically says that anyone that manufactures a device that distributes the internet, cell phones, tablets, computers, that they basically have to put as the default setting a filter that blocks pornographic content. And if someone wants to go and opt in, they can go and they can go to the retailer. They can say, I want to have this filter removed. So it's a digital blinder rack. I want to have this filter removed. They pay a $20 fee. And that $20 fee, there's another bill that's a constitutional amendment, and I want to take that $20 fee and have it go toward effective mental health and addiction treatment in our state, because we have such a critical need to really start effectively treating people. And I'm finding that most of the effective treatment is coming out of the nonprofit world, where they have, long-term residential treatment. They have programs and marry that with some traditional counseling resources and some holistic counseling resources, because our mental health issues, they're not just mental, they're emotional, they're spiritual. And if we can start treating them holistically, we're going to start getting better results with addicts, whether it's addiction to porn, addiction to drugs, addiction to alcohol, addiction to gambling. Addictions exist, and we need a way to treat those addictions in our state. Desperately need, because it touches just about every family in our state. You can talk to anybody, and they have a loved one, a family member, a friend, someone they know in their circle of loved ones that's impacted by mental health and addiction issues. So this resolution is just a statement to say, we recognize that this is a public health crisis. And again, we have a licensed professional counselor that specializes in this that I want to come and speak to the bill. But it kind of helps pave the way. So the 2 bills is HB 509, Human Trafficking Prevention Act, and there's a constitutional amendment that goes with that. And then I also have a study committee to study this issue over the interim, because those 2 bills will not be coming up until next year, because we were late in getting them drafted and dropped and moved through the process. But I want to take time to really study the issue. But this would really pave the way to go ahead and move this and set the tone that we recognize that this is a public health crisis in Georgia, and we want to do what we can, because we're supposedly the human trafficking capital of the world, and we need to do everything we can. And so the Human Trafficking Prevention Act, instead of, like he was saying, prosecuting and arresting our way out of the problem, it's actually getting to the demand side of trafficking. And we need something that's going to attack the demand side of trafficking, and that's going to be the most effective thing we can do to fight this problem in our state. So with that being said, do you want to go ahead and call?
I have one quick follow-up question.
Okay.
How is this going to affect the strip clubs that currently are licensed in the state of Georgia?
It has nothing to do with strip clubs whatsoever. This deals with obscenity. I mean,
Well, you know, okay.
You can have a strip club and people can go, and strip clubs can charge whatever they want to charge to have people come in. And Georgia has a $5 strip club tax. Texas has a $5 strip club tax. About the only bill, the companion bill with this that it supports is about the only human trafficking bill that actually makes the states millions of dollars annually, will help pay for all kinds of programs, help offset the secondary harmful effects. It does more than that, too. It actually, businesses are on our side because they, too, just like strip clubs, can charge their own admission. You can charge their own filter deactivation fee, an admission fee. So they're going to make, if the state charges $20 and makes $66 million a year, or if it's even less than that, whatever that number is, if businesses charge their own $20 filter deactivation fee, they would make the same thing. So basically, we're kind of against the side of those that want to proliferate human trafficking, those who want to encourage and proliferate the demand side of child exploitation, and we want the citizens of the state to kind of think twice before they interface with this content that is subversive to human flourishing, that does victimize people, as we have all these victims here who can attest to that, and it does lead to addictions. It's not to say that everyone who interfaces with pornography becomes, a child rapist or someone who hires a prostitute, but all the Johns we interview, most of them got their start through interfacing with easily accessible pornography online, and then it led to they wanted to have more hardcore forms of it, and then the next thing you know, there's this slippery slope of the heart that can take place, and they could end up, exploiting children, and they could end up on a plane flight and fly over to Taiwan. And so the truth of the matter, and this is what all the evidence suggests, and that is, we cannot prohibit strip clubs, and we cannot prohibit pornography, and we cannot legislate morality, and we are not trying to do that. But we do want to make barriers in place. So you talk about strip clubs and how it's related. The zoning strip clubs to the hard-to-reach parts of town is in and of itself a filter. We're making people think, we want the husband who's got 5 kids at home, and when he's driving the strip club at night to deal with his emotional challenges, to think, maybe I should exercise, or maybe I should deal with my emotional needs in a different way. Humans don't flourish best when they're getting off to pornography or they're getting off with prostitutes. And sex is a very powerful thing. And there's a lot of shame associated with sex. And so why the resolution is helpful for the public is because it helps them to think through. We're not here to shame anyone, but we do want them to think that, sex is all about context and healthy sex. And the legislature of the state of Georgia should help channel sexual energy in a way that fits with the truth of our nature and the truth about the way things are. And we have obscenity codes now. In one sense, the best question to ask would be, because we have existing state and federal obscenity codes, why do we even need a resolution? And the answer to that is because the tech companies have gone hog wild by doing whatever they want to do, and we're going to be regulating them in a way that is fair and doesn't hurt them. It just takes technology, which is good, and rolls off the dark side of it.
Okay.
Sorry.
All right.
Also, and technology, it takes the existing code that brick and mortar stores have to comply with, and it applies it to the internet.
Okay.
Because the content there is so much harsher and more involved than what the convenience stores are having to comply with.
Okay, we have 9 people that want to speak, and Representative Mathiak, you had your button down forever, so you want to go at it?
I think I do have one question. All right, and it may be more than that, but thank you, Madam Chair. When you sued Apple and the technological companies, did you also sue 800 and 900 phone numbers?
Phone numbers have no jurisdiction of that. This was a lawsuit against products.
That's a product.
Yeah, we're regulating physical products, saying the current condition these products come in are dangerous and defective. So it's a products liability lawsuit because, again, it's there's reasons why we're going to have a medical expert come and testify that to say that he's got waiting lists for people to come get treatment for internet pornography addiction, and while we have a female porn addict who was harmed and addicted when she was a minor by these products, who was driven down from Tennessee to testify.
You're pointing to one of our interns.
Oh.
She's trying to hide.
Is there something we don't know?
Yeah, that's
So, okay.
Madam Chair.
So,
and if we don't.
And what I wanted to say is the addictive part of pornography is the visual aspect. So the 1-800 numbers, that's auditory and not visual, and may not be as addictive, and but again, that's a free speech thing at this point, and it's legal to do that.
Madam
so.
Chair, one more question?
Yes, you make it brief.
Okay. On line 22 and 23, it says violence towards women and children with sex and pain and pleasure. Do you know that those receptors of part of the brain, it's the same receptors, pain and pleasure? So I would beg to differ that the auditory nerve is just as addictive as the eye.
Okay,
I got you.
right, that is.
And I would like to know if you won those lawsuits. Did you, whatever happened?
Well, here's the thing about the federal courts. It's different from state courts very often. What happened was, as we had multiple federal lawsuits, we went to the Sixth Circuit Court of Appeals. We had also, in California a case, in Texas, and what we did is we made everyone make all their best arguments for why they shouldn't be regulated. And if you look at the briefs before the Sixth Circuit Court of Appeals in the Google action, there's other cases too. It's clear, any lawyer, any attorney general who reviews it can see that, yeah, we can prevail and we have the right to regulate them. And it wasn't, they had 75 lawyers I was fighting against. There's probably, hundreds behind the scenes too. But, it wasn't like, well, the smartest lawyer will win. What wins is that we were relying on controlling Supreme Court precedent, and they couldn't get around the precedent in a case called Ashcroft and Ginsburg. And so the power of the litigation was to vet the law fully, because we're curing the failures of what's called the Communications Decency Act and the Child Online Privacy Protection Act, and we're not altering the internet in any way. This bill the other bill regulates products. We're just going to make it to where default settings are on a clean, safe mode, and people have to intentionally choose whether they interface. We're just shifting the burden. We have a mother here to testify who, she's part of that group of people that, doesn't want her children or herself even exposed at will to obscenity. And so instead of making her have to go out and buy some kind of filter or have to pay to make a product safer, the onus should be on the tech companies, number one, to provide the safety mechanism. And secondly, the onus should shift onto those consumers who think that interfacing with child pornography, which is illegal, revenge pornography, obscenity as defined under the Georgia obscenity codes now that exist, and prostitution hubs, make them have to take the extra step. And we're going to impose a $20 fee that will help the state, because that's a small price to pay to protect children.
We are going to we have approximately 11 minutes before committee members are supposed to go on a field trip. Not all of us are going, but enough of us, and I'm going to lose my quorum. So is there anybody here that came to speak from your group that can't come back at another time?
The counselor. And, Lauren too, but
That's from somewhere else, because, I'm going to lose my...
quorum. We want them to vote right now, don't we? Okay, so let's let him speak and then let them vote, I guess, right?
Are y'all taking a vote on this today?
No,
Okay.
I can't, because, we're going to run out of time, and you have other people, and
Yeah, well, if we only have 2 people speak, then and
I'll see what the
others-
committee
fine.
wants to do.
Okay,
But they
So-
need to go.
Okay.
right.
I think we're
Okay.
going to run out of time.
Yes, ma'am.
Okay.
Well, we might want to make them, ask them to have a vote today, possibly. Yeah,
Okay,
we do?
Yeah.
Okay, so talk for a few minutes.
pardon?
Uh,
Okay,
Can you say it?
I'm fixing to lose my...
Talk for a few minutes. Yeah.
Can you have like 3 or 4 minutes and?
What? Yeah, you can go ahead and speak. I'm just losing my...
Okay.
Okay, I'm losing my quorum and all.
Okay, I will make this very quick. My name is Eddie Caparucci. I'm a licensed professional counselor here in the state of Georgia.
Stop
I have a private practice in Marietta. I have 2 certifications in sexual addiction. The reason I'm here today to talk to you is because I just want to talk to you about why I believe that pornography is a public health hazard. And it is for many reasons. See, I'm in the trenches, and I'm seeing what it does. I'm seeing the outcomes, the destructions of marriages. I'm seeing what it does to children, how it taints their view of sex, how it makes them look at women as objects. It shows them that, you know what, it's okay to demean women. I spend a lot of time looking at people and working with people who have suffered a lot of problems, whether it be financial, because they're spending enormous amounts of money on pornography that they don't have. We have people who are missing work because they get lost in time warp when they go on to porn for a little while. And so anyway, it's a big issue.
Representative Sharper.
Oh, I mean, I'll waive because it was more related to the bill that you guys were working on, but I can talk to you later or something like that.
Okay. All right, I think the thing for us to do, can I have a vote to lay this on the table, please? Do we have enough to even do it? No, we don't have enough? Okay, we're just gonna have to discontinue it because we don't have enough. So, we'll see about getting it scheduled. We've just gone longer, thanks to them browbeating one of the earlier bills and going too late, so. And there's nobody else that wanted to speak, right, that testify, that came a long ways.
Because of that, yeah, we'll go ahead. I'm sorry, we tried to cut it off before the
Okay,
forum.
well, I'm losing it. Okay, do you want to go ahead and speak? I hate for people that travel a long ways that, it's difficult to come back.
I'll try to make it as quick as possible. My name is Lauren Dixon. I live in Nashville, born and raised. And when I was 16 years old, I grew up the cookie cutter poster child, I like to say, for parents, raised in the Baptist church, didn't drink, didn't smoke, never kissed a boy, didn't have a boyfriend. And my friends were like trying to educate me on sex. And as much as I was like, yeah, I'm not listening, got curious, but had too much pride to go and ask them what they were talking about. So a few clicks of Google to answer my questions. Fast forward 6 months down the road, turned into a full-blown porn addiction that lasted for about 3 years. When I went to college, decided that I would tell myself to stop and couldn't. I developed such a bad anxiety disorder from trying to hide what I was doing and just living a double life that I had to drop out of college and move back home. And after about a year of counseling and medication and lots of therapy, have been clean for about 3 years, but it's a daily battle. And fast forward to now, counseling other women that struggle with it as well. And it's not just, I think in society it's viewed as a man's issue, and protecting like our boys, but it's a women's issue as well, especially in the church. So I just wanted to share my story just to give you a person who I look at what my life could have been and dreams that I had of going to school and where I wanted my life to be, and because of my addiction is 360 in a different direction. So thank you for your time.
Are you just saying that, it just consumed your time and of watching
my time,
porn
and the whole anxiety, panic attacks. I got to a point where when I had moved back from college where I didn't want to leave the house, to where it just consumed me all the time.
Okay, Representative Sharper has a question, but let me thank you for coming and being willing to stand up in front of all of us. Did you have a question for?
Yeah, just a comment for them. Thank you, Madam Chair. If we bring this back and look at it, I'm just going to give you some advice to stick with your resolution and not talk about your other bills, because that can easily become a situation. I saw it come up a little bit. We were talking about your bill when we're trying to look at this, and I support what you're trying to do in your efforts on the resolution, but I wouldn't bring in talking about the other bills because that's going to make somebody vote on the bill that's not even here, okay?
That's it. Was there somebody else that wanted to testify that came a long distance? Or anybody? Okay, sure.
Hillary, come back.
Okay. I'm sorry that we have to cut it off, that it's gone. Like I say, they had a field trip that's been planned, and I didn't want to keep any of the members from going it. So thank you to the members for sticking it out this long. We are dismissed. Thank you, Representative, for bringing it, and thank you.
Yes, ma'am. Thank you, ma'am.